Any mention?
Yes, may I please, Lordship, I beg to mention item number 15. This matter may come up after 4 weeks, Lordship.
Item 15, the last
Yes,
item.
last, Lordship.
This one,
Quashing, Lordship. And similar matter is also there in the DB.
Pending for
Yes,
DB.
Lordship.
First.
That matter has not been taken up till now. No.
No, Lordship.
When it is coming up, likely to come up?
Also, there is no tentative date.
Okay. Yes, sir. At the request. Made by the parties. This is matter after 3 weeks. 3 weeks, Lordship.
Your Lordship, I'm appearing for the private respondents in this matter.
Yes, left to the state. Yes.
Obliged, Your Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 12, Your Lordship.
Yes,
I pray this matter may come up after 2 weeks, Your Lordship.
you are appearing for petitioner.
Yes, Your Lordship.
Who is the other side?
And for the state is Ma Bhattacharjee.
No objection. No objection.
No objection, also. It has been joint request.
Made on petitioner just after 2 weeks. Yes.
Much obliged, Your Lordship.
And oblige, Lordship.
My Lord, I beg to make a mention of item 11, my Lord. Is this matter kindly be listed after 4 weeks, my Lord?
Yes.
But board has not yet checked because CEO has gone for training. He is back day before yesterday. Maybe I think it in 2-3 weeks' time.
Is there any likelihood that it
Yes,
something will be?
2-3. I think 3 weeks' time it should be over. I think.
Okay, this is also the request made on behalf of the petitioner. Not objected to by the learned senior counsel in appear for the respondents. List is matter for 3 weeks.
Obliged, my Lord.
May it please your Lordship. Lordship, I beg to make a mention of item 10.
Mr. Paul.
Lordship,
Yes.
My Lord is in his bereavement.
Yes. How long you want?
Lordship, 3 weeks.
Same order. Make it same order. Make it 2 weeks. Yes.
Lordship, a similar prayer for item 14.
Item 14. Who is the respondent?
Lordship, GHADC.
Oh, yeah.
The
You are
other
the respondent. Item 14. You are appearing for the
Petitioner, Lordship.
no. You do not know you are appearing for which party.
Lordship, I do.
Where is the
apologize.
petitioner?
Lordship, I'll inform them. I undertake to inform the other side.
Mr. P.T. Sangma
Lordship.
and District Council.
Lordship, I undertake to inform them as well.
Okay, this is also. But then you are appearing for respondent number. Which respondent? You do not know.
Lordship, I do apologize.
That is a problem. You say, please find it out. Give it to them.
Lordship.
Just say the request made on behalf of the respondent number so and so so and so. This is matter after 3 weeks. Yes.
Grateful, Lordship.
Lord, I beg to make a mention of item 9, my Lord. Here, my Lord, H. Hazarika is the conducting counsel. My Lord, he is fractured his leg. So is unable to appear before this honorable court. So, my Lord, it will be 8 and 9, my Lord.
What leg has to do in the argument of the matter? Yes. When do you want it?
And, after the 3 weeks, my Lord.
Just say a mention has been made on behalf of Mr. H. Hazarika. Learned GA appearing for the state respondent on the ground. Has been made to adjourn the matter. Mention has been made and we have so and so. Right. To adjourn the matter by 2 weeks on the ground of illness of the learned G. The prayer has not been opposed by the learned counsel applying to the petitioner. Prayer alert, list after 2 weeks. 2 weeks will be alright.
But
2 weeks. Alright.
Authorised.
Item number 1.
Yes. Where is the petitioner? This is a CRP.
My lord.
Under 227. You are appearing for the
State, my lord.
this is a
You are
revision
supposed to
against-
take steps on the private respondents as per the last order.
Have they taken steps for that tape?
That I don't know.
Yes. Notice return answered. You are representing whom?
State, my lord.
State is a party here in this matter. State is what? State is
sorry,
not a
madam.
party, Mr.
I'm
It
sorry,
seems
madam.
like that.
There's a mistake,
It
my lord.
seems councils are not even aware about what case.
Well, I apologize, my lord.
None appears for the petitioner. List after 2 weeks.
Item number 2.
Same. Same order. Same order.
Item number 3.
Step has been taken, Your Lordship.
Yes, there is no service report. What to do? You have to
Yes.
wait for some time.
Yes, Your Lordship. Let's wait. If did not appear,
The office note indicates the land council of the petitioner submits that steps for service of notice upon the sole respondent has already been taken. The office note dated 18/2/2025 indicates that service report is yet to be received. Stop. Await report of service list after 2 weeks.
all right.
Item number 4.
Lord, may pray, my lord, may kindly take item number 5, my lord.
May it please your lordship.
Yes, give item number 5. 1 minute. Yes.
Lordship, in item number 4 and 5 are same matter, analogous matter, your lordship. What happened, your lordship? Okay, I'm handicapped because what happened, the investigating officer who is supposed to brief me to give me instruction, he has been assigned on election duty.
But then that is pending for instruction for quite some time.
Yes.
Mr. Lord. At least we should know the status of the investigation.
Lordship, if
And
this
it's, my lord, almost
this matter
17
can-
months since the case has been registered. In fact, only a
this matter
very,
can be taken up by lordship after some time, say for after 10 days or 2 weeks, your lordship.
my lord, my prayer would be subject to your lordship's convenience. Let me place my case, my lord.
That is all right, but then if we cannot decide the matter, then what is the
No,
purpose?
my
of
lord,
keeping
what I was
this?
trying to impress upon your lordship is on the very first day, while issuing notice, lordship issued notice on the interim prayer also. Now, my lord, issue is whether they can go ahead with the investigation. Your lordship, kindly give me 5 minutes time, my lord. I would like to place 2 paragraphs
You
from
have
Bhajan
plenty
Lal.
of time. You have plenty of time, Mr. Jyoti.
Yes.
There is no problem with it. The only thing
Only
is
thing is, my lord, here is a case. I'm sorry, my lord. We have already demonstrated, my lord, ingredients constituting the offence is totally missing. They say, my lord, the date of occurrence is 28/3/23, and the stockist to whom we are supposed to have criminally intimidated they were appointed in September, my lord. Absolutely, my lord, improbable. And therefore, my lord, the Supreme Court says, my lord, before you start the investigation, it is the duty of the investigating officer to find out whether it's a case where you should go ahead. And just 2 paragraphs, my lord. Vajan Lal's case, I've already given on the last occasion, my lord. If your lordship, that is 1992 supplementary 1 SCC 335, my lord, para 49 and 51 at page 362. Resultantly, I'm sorry, my lord, page number 362.
No, have you supplied the copy?
Yes, yes, it is there, my lord. Last occasion it was given. We have checked, it is there. Not with the compilation. It is not with the compilation, separately it is there.
Yes, page?
Page 362. On top, para 49.
Yes.
Resultantly, the condition precedent to the commencement of investigation under 157(1) of the code is the existence of reasons to suspect the commission of a cognizable offence, which has to be prima facie disclosed by the allegations made in the first information report laid before the police officer under 154(1). In West Bengal versus State of West Bengal versus Sapan Kumar Guha, Chandrasud CJ, while agreeing with the judgment of Justice A.N. Sen, with which judgment Justice Vadrajan also agreed, has expressed his view in a separate judgment on the above point under discussion as follows. The position which emerges from this decision and the other decisions which are discussed by Brother A.N. Sen is that the condition precedent to the commencement of investigation under section 157 of the code is that FIR must disclose prima facie that a cognizable offence has been committed. It is wrong to suppose that police officers have an unfettered discretion to commence investigation under section 157 of the code. Their right of inquiry is conditioned by existence of reasons to suspect the commission of a cognizable offence, and they cannot reasonably have reasons to suspect unless FIR prima facie discloses the commission of such offence. As pointed out in the earlier part of the judgment, section 157(1) is qualified by proviso, which is in 2 parts, A and B. Clause A of the proviso is only an enabling provision with which we are not very much concerned. However, clause B of the said proviso imposes a fetter on a police officer directing him not to investigate a case where it appears to him that there is no sufficient grounds in entertaining on an investigation, as clause B of the proviso permits police officer to satisfy himself about sufficiency of the ground even before entering on an investigation. It postulates that police officer has to draw his satisfaction only on the materials which are placed before him at that stage, namely the first information report, together with the documents, if any, enclosed. In other words, police officer has to satisfy himself only on the allegations mentioned in the first information before he enters on an investigation as to whether those allegations do constitute a cognizable offence warranting an investigation. Therefore, my respectful submission before Lordships is, my Lord, unless the IO satisfies your Lordships that these are the materials which enables me, Lordships will not permit them to proceed with the investigation. That is my prayer to them.
Understood. But then the thing is that the FIR
Yes, my Lord.
was filed probably years back.
It was filed about 17 months back.
So that is why, you see, before we pass any order, that was what
No,
is
all
what-
that I am
wait,
saying is, I'm sorry, my Lord.
But we wanted to see
Yes.
what is the progress of investigation, whether at all it is pending or it is closed or not. So that is what. So supposing if the matter is closed, so no order would be required to be passed. So that is what we wanted to know. So anyway, Mr. Sulai, we'll do one thing. We will keep this
on the next date, your lordship, something I'll place the instruction on the
without
next
making
date.
elaborate order, we'll say that you are asking for further time.
Your lordship.
So then we'll stay in view of that.
Yes.
That will be. In the miscase, you say, despite of opportunities provided on the earlier occasions, it is submitted by the learned AG, appearing for the state, that he is yet to receive any instruction from the investigating authority. The learned senior counsel, appearing for the petitioner, submitted that none of the ingredients of the offence under which the case is registered are borne out from the allegations made in the FIR. He further submits that the investigating authority is duty bound to satisfy itself on the sufficiency of ground for launching an investigation based on the materials and information provided in the FIR. He contends that in the present case there is no such ingredients available. Stop. Give a paragraph. It appears that the contention raised by the learned senior counsel for the petitioners are vital and requires elaborate consideration by this court. In view of the above, a further investigation of the case.
Yes, my lord. FIR number 0248 of 2023, dated 11/9/23,
Shall remain stayed.
of PS Sadar, Khasi Hill East.
Shall
Deep
remain
level.
stayed until further order,
Deep level.
so that we do not have to this thing. And in the main case,
Yes.
we just say
Same order will
Same.
follow in item 4, Your Lordship.
and then in both the cases you will be representing.
In 5 I am appearing, in 4 my learned
But
friend
you have
Mr.
made submission in 5.
Okay.
Anyway, you just put the name accordingly, because you see, like, we do not know who is appearing on them, so we do not want. And then in the main case, you just say as paid for by Mr. Andy Shulle, learned AG. How much time you will be reading?
It will be 2 weeks, Your Lordship. Next time.
So those it's all
Deep level.
right.
Apply, Your Lordship.
Item number 6.
Your Lordship, I'm appearing for respondent number 2. I pray for 4 weeks' time to file our objection, Your Lordship.
In this criminal petition, what sort of objection is needed?
We have taken leave from the your honor.
You are the complainant.
Yes, Your Lordship.
What you are seeking? The quashing of
Question of the FIR.
FIR lodged by the private respondent. Alleging what? What have you alleged?
Your Lordship.
What is your allegation in the FIR?
Domestic violence, Your Lordship. Domestic violence.
Domestic violence. Oh, Asha, you are husband and wife.
Yes.
It's a matter between husband and wife.
Yes, Your Lordship. But I'm appearing on behalf of the in-laws of the wife, Your Lordship, the
Because they are-
parents of the husband, Your Lordship.
So husband is not a party here.
No,
He
Your
is a
You are
party.
the in-law.
Husband is a party also.
So husband also is party. Now, in this presently, is the husband is a party.
Yes, husband is party also.
In this quashing application,
No,
husband.
no, Your Lordship. He's not a party in this case, Your Lordship.
I'm so sorry, Your Lordship.
See, what happened? We do not know why so much of wrong submissions coming from the bar. Sometimes the councils are not aware they are representing which party. This is something wrong. Anyway, you are appearing for the private. So you have any objection? Let them file.
Yes, Your Lordship.
You are appearing for?
For respondent number 2, Your Lordship, the complainant.
This is your first appearance today.
Second appearance, Your Lordship.
Okay. The
Your Lordship, I
your
pray
name,
for
please.
4 weeks. I pray
Give
for
your
4
name, please.
T. Maranga.
T. Malla, learned counsel, appearing for the respondent number 2. praised for and granted for the 2 weeks time.
4 weeks time, yeah, because the complainant is not well, that's why we could not meet her, Your Lordship. The complainant is not well, that's why we could not meet her.
You take 3 weeks, he required you ask for time. Praised for and granted for the 3 weeks time for filing an objection in the matter. Please take
Obliged.
Yes, obliged.
Item number 7.
Your Lordship, it's matter service reports awaited, Your Lordship. I pray that matter come up after 1 week.
There is only respondent number. It is pending for appearance to respondent number 4.
Yes, Your Lordship.
The notice has not been served or served.
I have to confirm from only
You have
1
to
week.
confirm.
Yes, sir.
The land council for the petitioner submits that steps for service of notice upon the respondent number 4 has been taken. However, service report is still awaited. You will verify the status?
Yes, sir. 1 week time.
The petitioner to verify the status of service upon the respondent number 4 and file an affidavit
Yes, sir.
to that effect. List after 2 weeks.
Obliged.
Item number 8.
Yes.
Wait, please, Your Lordship. Lordship, the landed DSJ is on legs before court number 2.
But then he will be coming, isn't it? He'll be available after some time, isn't it?
He may be, sir. Lordship.
Anyway, let us see. What is this, Mr. Jha?
My lord, this is a case where the dismissal from service, my lord. But this is a peculiar case where the horse has been put before the cart.
How? Why?
My lord. Before any complaint, my lord, before any complaint, inquiry was initiated against the petitioner. It is admitted by them in the affidavit that the complaint received in the month of December, such and such, such and such.
Complaint received in the month of December. Who is the complainant?
No,
Who is the complainant?
no disclosure, ma'am. And the court of inquiry was initiated in August 2016. And based on that court of inquiry, ma'am, the complaint, what is the complaint? That is also not annexed.
In the court of inquiry, you have taken part.
I have taken.
You have not challenged the proceeding before the court of inquiry.
My lord, that even the complaint, I was not given a the stand is there. I was also not given a proper opportunity under 183(8) of
No,
the.
you are coming to this thing. First, let us just fasting fast.
Mal.
You say that it is like putting the cart before the horse.
Mal.
Before horse, isn't it?
Mal.
Now, your contention is that before there existed any complaint, the inquiry had started.
Inquiry.
Now, normal logic is that if you find any initiation of inquiry against you without there being any complaint, you come in and definitely challenge the inquiry. So, was there any challenge to the inquiry proceeding by you?
In that time, my lord, in the writ petition, I have challenged, my lord.
Not in the present one. You have the now inquiry is over, isn't it?
Inquiry is over.
Before conclusion of the inquiry, the time when it was initiated, whether it was challenged by you.
That fairly something.
So, if you allow
Mal.
an inquiry to proceed
Mal.
without any objection, and that culminates into whatever,
Mal.
where is the scope of coming and challenging this inquiry now by saying that
Mal.
there existed no complaint?
Mal.
Until and unless there is something to show that you have not lodged any complaint against the initiation. You may very well challenge the inquiry by taking other grounds, as you say, that no opportunity was given to you, and even the finding of the inquiry on the basis of perversity or any other permissible ground. But then, can you now say that there existed no complaint?
My lord, that's it's in the affidavit they have brought that, my lord.
Brought what?
That a complaint was received on such and such date to the PMO office.
So, anyway, so you had no information about that?
Nothing.
So, that is where you doubt the
action of the
very inquiry and its purpose,
my lord.
The intention behind it. And what are the other grounds?
My lord, it is the dismissal was for the impugned order is that.
What is the allegation against you?
Allegation is that I have submitted a fake certificate.
There is no provision of appeal?
My lord.
Under the rules, related service rules?
Statutory appeal challenging the dismissal, my lord, I have to check that.
See, as you understand,
Mal.
the scope of writ petition is very limited. We may not go into the facts of the case to reappreciate it. You have to only confine to the procedural infirmities.
My lord.
And the violation of principle of natural justice. So, until and unless you can establish it, which we can interpret. Now, second proposition, which has been reiterated by the Apex Court time and again and recently, the Apex Court said that when there is a scope of preferring a statutory appeal or the appeal provided under the rules, the writ petition in normal situation should not be entertained. You have to state the reason Why specifically you have
I
invoked the
approached
writ jurisdiction? By avoiding the appellate authority.
As far as my lord, that statutory appeal, I have to check my lord. This has come. I will check my lord whether that, as far as the dismissal order is concerned, my lord, based on any of the finding and opinion, my lord, of a court of inquiry, whether a statutory appeal lies before initiating that under the Assam.
Before initiating means, are you in service?
No, my lord.
So after the inquiry,
My lord.
what happens as per the norms when
After
inquiry
the-
goes against you?
My lord.
What
They-
happens? Just
they
the
issued
report
a-
of the inquiry has to be accepted by the concerned authority, isn't it?
Confirming authority.
Confirming authority, and thereafter only order of dismissal can be passed.
My lord.
So in your case, that has been done.
No, my lord. In my case, my lord, a show cause notice was issued.
Sit down. So you can sit down. Yes.
My lord, a show cause notice was issued to me, which I have challenged. I have replied, and thereafter, dismissal order was issued against me.
No, but then you came to know later that there is an inquiry.
My lord.
So show cause notice before inquiry.
No, my lord. After inquiry.
No, then before initiation of inquiry,
My lord.
where you have taken part, what was issued to you? What is the what
A
is the-
convening order, my lord.
what is the procedure? What is the provision of law which guides those things, those processes?
My lord, as far as any inquiry is concerned, my lord, under the Assam Rifle or Army, my lord, convening order to convene a court of inquiry, that I have annexed, my lord.
So court of inquiry comes, when court of inquiry comes, before that, was there any procedure of issuing show cause? Or it is directly on the basis of complaint a court is convened?
My lord, that as far as under the CCS rule, it's there, my lord, but
Assam
under
Rifles-
Assam Rifle,
You have a separate set of rules, isn't it?
yes, my lord.
So we will not go guided. We will not be guided by CCS.
Now, after
So you have to place it
2006,
before the court.
my lord, I will
When shall we
check.
have it?
Lordship, after 2 weeks.
Not after 15 minutes.
I will put those queries, my lord. I will definitely.
You please place before the court
My lord.
what is the law regulating this part of the departmental inquiry and all. Okay, and where there is a procedure of issuing show cause. See, normally as per service, what we understand, before an inquiry is ordered, first incumbent is given a show cause notice. Now, depending on the reply of the satisfaction of the authorities, they institute inquiry. If his show cause is accepted, no inquiry is received. If show cause is not accepted, then inquiry starts.
That's a service.
And then, depending upon the report of the inquiry,
the
further
second
action is
second
taken.
show cause.
Second section, when they decide to give you
The punishment, my lord. That's second show
So
cause.
that is what. Okay.
I
If
will-
inquiry committee's report is accepted by the authority concerned, then only the question of awarding punishment comes, and then the question of giving show cause comes,
My lord.
isn't it?
My lord.
Now, that is a normal procedure,
That's under.
and that is followed where the departmental proceeding is not guided by any rule also,
My lord.
because this is in adherence of the principle of material law. Now, so far as
Assam
this
Rifle.
matter is concerned, you have a set of rules prescribing the norms. So that is what
My lord.
we'll just say at the joint request.
My lord.
At the joint request made by the parties. This is matter after 2 weeks. After 2 weeks. Another matter.
My lord.